I did not write out my testimony. I had a hearing this morning and I got canceled last week, so I was happily able to testify, but I can draft something and submit it after if that's agreeable. I'm here to support HB 455. My name is Jonathan Cohen. I am an attorney. My practice is here in Concord. I live in Hopkinton. And I'm here to speak to you as a victim. So when I was in college, I went with some friends to Long Beach Island. I had never been there before. My friend lived there. And I can remember hanging out with my friends, and my friend's mother came into the living room and said, "Your father's on the phone." And I didn't even know that he knew where I was. And this is back in the days when we didn't have cell phones and the phone was actually tethered, So I went into the kitchen and I picked the phone up, and I was so surprised that my dad had called me. And he called me to tell me that my grandfather had been murdered. And I can remember holding that phone and letting that sink in and feeling like it was a very surreal moment in time that I will never forget. And my grandfather was a very important person in my life. His birthday was the day after my birthday. And my grandparents lived in Florida, but they were snowbirds. And in the summer, they would come up to Keene, and they would stay in Keene, New Hampshire, so they could be close to my brother and me. And we spent a lot of time with them. And we would celebrate our birthdays together in the summer. The loss of him is hard to put into words, and I'm a guy who gets paid to speak. And I think about him frequently. But what I'm here to tell you today is that to kill my grandfather's killer will not serve any productive purpose whatsoever. It will not serve any deterrent effect whatsoever. And as I mentioned to you, I'm a lawyer. I've been practicing criminal law in this state for 20 years. I have represented murderers. I have spent lots of time in prisons and in jails. I have stood next to someone who was sentenced to life without the possibility of parole. I have represented others. It's important to keep in mind that around the same time we've heard a lot about Addison, there was another capital case in this state, the case of State v. Brooks. This was an older white individual who was convicted of murder for hire, hiring people to kill someone else. He got life without the possibility of parole. You don't hear anyone saying, well, where's the deterrent effect? That's concerning because he got life without the possibility of parole. There's not enough deterrence in the sentence. You also, from the people that talk about Addison, don't hear people, they say, well, there's a deterrent effect, but it didn't deter him. So what is this deterrent effect? The judges that we've heard testify, I've been in front of all of them. You don't hear criminal defendants saying, well, I carefully weighed the pros and cons and decided to commit a murder. That's not how murder cases go. So I see that my time has come to an end, but I will leave you with this. This is a moral choice. And I urge you to make the right one here. It is time to repeal the death penalty. And I thank you for your time.
Thank you for coming and testifying. Are there questions? Madam
Chair, thank you for your testimony.
Thank you.
You had mentioned, you said State v. Brooks,
Yes.
murder for hire. And earlier testimony we heard in 1997, an officer was killed but did not get the death penalty. Is this the same? Was it-
No, this was not a police officer that was killed, but it was a murder for hire. It was a capital case that was brought around the same time as the Addison case was tried, with very different effects. Mr. Brooks received life without the possibility of parole. Mr. Addison, obviously, those two crimes are different crimes. I'm not suggesting they're the same, but they're both capital cases that resulted in different sentences.
Thank you.
Yes.
Senator Carson.
Thank you, Madam Chair. Thank you for your testimony. I'm looking at the statute here, and it's 605, 630, and the fifth section that speaks to, the seventh section that speaks to the aggregating factors after someone has been found guilty. And I think it's important that people understand that there is a long list of factors that are taken into consideration when someone is when they're considering the death penalty for one person versus another. And it actually says, if the defendant is found guilty or pleads guilty to the offense of capital murder, the following aggravating factors are the only aggregating factors that are to be considered, unless notice of additional aggravating factors provided under subparagraph. And again, there is a very, very long list for consideration. So that could be the reason why, in one instance, you have someone who was given life without parole versus someone who has been sentenced to death. Would you agree with that statement?
What I would say to that statement is, first of all, in the aggravating factors, the catch-all that you read there can be additional factors that can be considered as long as the prosecutor notices them up and then the court holds a hearing on those factors. But I think that you raise a really important point, which is that depending on the quality of the counsel, depending on a whole slew of factors, you may have different sentences imposed. You could have different jurors. You could have different jurors that had different biases, whether explicit or whether just biases that they have that they're not even aware of, that could affect the ultimate outcomes of two very similar cases. And that is an extremely important thing for the committee to consider. That the law, and I think the judges and any lawyers and anyone else that's had experience with this will tell you that it is not a machine. It does not stamp out the same result for every single similar thing. And this is part of the reason that life without is so much more just than putting someone to death, because it could be due to variables that, the defendant may not be able to control, such as how he appears, such as his race or economic status, how he presents himself, how he speaks. These are not the reasons to kill someone.
Can I follow up, Madam Chair? Thank you. I'm looking at this, and I'm not going to read them just because we do have time issues.
Absolutely.
But in these aggregating factors, there is no reference to race. There is no reference to, they're very, very specific, and I would argue that this is one reason why we have not used the death penalty in many, many, many years. It's because the bar is so high for someone to get that death penalty. And I think that is an issue that needs to be clarified here. That we just don't routinely charge people as they're going through
We do not.
and they get the death penalty.
We do not.
It really has to be very, very, very clear what has happened. And so I would just ask that people take into consideration what those aggravating factors are. They're spelled out very specifically within the RSA when we're talking about the death penalty.
Right. And what I'm speaking to is the fact that the law always comes down to people. When you have a jury making a determination about a factor, say whether the defendant is redeemable, whether there's someone who can become a better person, whether they're going to be a danger while they're incarcerated, every person carries with him or her some implicit bias. They may not be aware of it, they may not be a bad person, but we're all affected by our experience, by the people who are our friends, by the people who are our families, by the people that we spend time with. And that implicit bias could affect somebody's determination about whether or not someone is so dangerous they must be put to death or shouldn't be. So that variable is a very important thing to think about when we talk about something as important as justice.
I will, at this point, respectfully disagree with the speaker. Thank you very much.
Thank you.
Thank you for coming.
Thank you for your time.
I see no further questions.